frequency that we're doing these every couple of weeks. So this morning, Matthew and I are going to talk about the furlough scheme and test and trace. So first of all, I'll be looking at the coronavirus job retention scheme, or what we otherwise call the furlough scheme. As I'm sure you're all aware, that changes were announced to the furlough scheme by the Chancellor on the 29th of May. And so the guidance on the scheme has been updated for those of you that frequently look at the relevant pages on the government website, but they've only been updated to the extent essentially of the Chancellor's announcement, and further more detailed guidance, particularly in relation to how flexible working / flexible furloughing is going to operate. It's due on the 12th of June, so what's that? That's next Friday. But for those of you who are currently relying on the furlough grants due to the impact of COVID-19 on your business, or contemplating the use of flexible furloughing from the 1st of July, we actually felt it was worthwhile, even though we haven't got all the details at the moment, to discuss the coming changes to the job retention scheme, and to discuss what you need to be thinking about and the potential issues we can see on the horizon. So I'll be talking about that, and then afterwards Matthew will be looking at the test and trace. This is obviously a central part of the government's COVID-19 recovery strategy, and its aim is to help us to return to some form of normality as quickly as possible, but in a way that is safe. So Matthew's going to look at the scheme, and in particular he'll be looking at how it will be implemented in the workforce, and potential issues arising from that. So firstly, looking at the coronavirus job retention scheme, and I'm just going to pause while I wait for the slide to hopefully magically appear. There we go.
Vanessa?
Yes.
Hi, just before we start, hello everybody. Do you just want to say how we'll deal with questions?
Yes, sorry. That's me getting carried away in the excitement and anticipating your regular viewers. Sorry. Yes, good point. So what we've been doing, what we'll continue to do is give you the opportunity to type in the chat box and ask any questions about what we're talking about. And we will try and answer these as we go along the webinar. And so please do feel free to ask questions, and we'll deal with these and answer them. And also we'll spend some time at the end of the webinar to capture any questions that we haven't answered as we've gone through. And we'll be around for as long as you need us this morning.
Sorry, I'm going to interrupt again. There's a few people just coming through saying no sound. When we've had those comments in the background, we found it's people who are not on Chrome as the browser. If you log in via Chrome, then there tend not to be sound problems. And I think also Firefox and Safari are okay. The problem seems to come with Microsoft's Edge. But if any of you are on Chrome or one of those others and you're experiencing sound problems, let us know, and we'll see what we can do.
Okay, and sorry, I think we've got now. promises. But we've also got Amy in the background, so hopefully I'm sure she'll be reaching out to those that are saying that they're struggling to hear us. Okay. Coronavirus job retention scheme. As I said, there was an announcement by the Chancellor on the 29th of May. And he announced how this scheme will be operating over the coming months and eventually terminate. There's a fact sheet that has been produced by the government shortly after his announcement, and that said that as of midnight on the 24th of May, the scheme had been used by 1 million employers to protect around 8.4 million jobs, and the total value of claims made was 15 billion. Interestingly, the statistics were updated, I believe, yesterday or the day before, and the government's latest figures reveal that actually now 17.5 billion have been claimed under the furlough scheme. And interestingly, a total of 8.7 million workers are now on furlough, and that's seen a jump of 300,000 workers being furloughed in the last week. No doubt because, as we'll come on to, we do have a cut-off point where people can access the scheme for the first and last time, but I'll come on to that in a moment. But what is interesting is actually that what they're estimating is that a quarter of the UK's workforce is currently on furlough. So that's obviously a huge proportion. So the key points from the announcement are what we've put up on the slide there. Furloughed employees are going to be able to work part-time from the 1st of July. We're now going to see a tapering of support from the 1st of August and through to the end of the scheme. And the scheme is going to end on the 31st of October this year. So the first thing I want to look at is the tapering of the scheme. And this chart here just shows you how the government contributions to furlough are gradually going to taper. So if you look at the 1st of July, the level of government support is going to continue as it does at the moment, which is basically the government continuing to pay 80% of salary, subject to that monthly cap of £2,500, plus national insurance contributions and pension contributions. But also in July, this is when flexible furloughing is going to start as well. And then from the 1st of August, the tapering starts. So whilst the government's going to continue to pay the 80% of salary, subject to that £2,500 cap, the employer is going to need to pay the employer national insurance contributions and pension contributions. From the 1st of September, the government's going to be paying 70% of wages up to a monthly cap, which is obviously proportionate to the cap that is currently in place. And again, the employer will also need to be paying, as well as that 10% top up, the national insurance contributions and pension contributions. And then in October, the tapering increases slightly more by another 10%, so that the government will be paying 60% of wages, and the employer is paying the 20% and all of the employer national insurance contributions and pension contributions. It's important to note that as we currently understand it, for the duration of the job retention scheme, furloughed employees will be entitled to 80% of pay, subject to that cap of £2,500. So it appears that the employers, we're going to be unable to essentially ask furloughed employees to take corresponding pay cuts as the tapering goes along. So what I mean by that is that we're not going to be able to ask our furloughed employees to suddenly reduce their pay from 80% to 70% and then 60% in October. The government press release that announced the changes does state, crucially, individuals will continue to receive that 80% of salary covering the time they are unable to work. It also states that employees who believe they are not receiving their 80% share can report any concern to the HMRC hotline. The other point to note is that as furloughed employees can return to work on a part-time basis from the 1st of July, the monthly caps, so the £2,500 a month and then the £2,187.50 cap in September and so on. These caps are going to be proportional to the hours not worked. So it's not going to be, for example, the cap would apply so that if you had an employee who was a high earner and who worked 2 days a week and then was put on furlough 3 days a week, the cap would still be £2,500. It won't. It'll be proportioned down on the basis that they'll just get 3/5 of that cap. That is my current understanding of what it will be. But as I say, we are waiting for final details. As with the previous scheme, of course, it's up to employers to choose whether they would like to top up employees' wages above the scheme grants at their own expense if they wish. So obviously some employers will still top up at the moment to 100%, or some perhaps top up to 80% where the cap affects employees. So that will still be open for employers to do. And quite interesting, actually, that fact sheet that the government prepared on the job retention scheme does say that they expect the changes in August not really to affect so many employers, because apparently they have concluded that around 40% of employers haven't actually been making claims for employer national insurance contribution costs or employer pension costs, which I found quite interesting, because 40% is a high percentage, and you would have thought that those that have been accessing the scheme would kind of claim all the grants that they were eligible to receive, but that's what the government is saying. So moving on to some key points really for you. So the scheme is going to close to new entrants on the 30th of June 2020. So after the 30th of June, after the end of this month, employers are only going to be able to furlough employees who have already been furloughed for the minimum period of 3 weeks. So therefore, this is where the 10th of June date comes in, because therefore the last date on which employers can furlough employees for the first time is the 10th of June. And it's the 10th of June, so that 3 weeks will be fitted in before the 30th of June. So the fact sheet, again, which I referred to, said that the number of employees an employer can claim for in any claim period can't exceed the maximum number they have claimed for under any previous claim under the furlough scheme. And this is going to be particularly relevant for some of you that have been operating rotating furlough arrangements under the current scheme, because of course that will probably reduce the number of employees you have on furlough at any one time because you're rotating. So just watch out for that, because the government will be, the scheme does say that you can't have, from the 1st of July, you can't have any more employees furloughed at one time than you have previously. We had one, I know I can see some questions coming through, but I'm not going to look at them at the moment. I'll deal with them shortly. But we did have one question that came through prior to this morning, which asked companies that have been rotating staff on furlough, if they have been previously furloughed for 3 weeks, but brought back to work in June on a rota basis, must they be furloughed again on the 10th of June to be able to continue being on this rota scheme and furloughed again in July when they are replaced with the other workers on the rota? Or does the cut-off date only apply to people brand new to furlough and who have been on and you haven't been on it at all prior to that point? Well, the answer to that question is the latter statement. So basically, if you have somebody who's been furloughed and perhaps they were furloughed for all of May, but they are working in June, they can still be put back on furlough in July, August, September, October. It's just the people who can't access the scheme or those who have not been on furlough prior to the 10th of June at all. So hopefully that's answered that question. And now moving on to the flexible furloughing, it is very much as we expected and as we anticipated, because it's been asked of the Chancellor fairly frequently shortly after the furlough scheme came into place, that actually the scheme allows flexible working from the first that allows flexible working. And so the Chancellor's confirmed that flexible working can start from the 1st of July. He's also said that employers may agree any working pattern with previously furloughed employees. So there seems to be quite a degree of flexibility around how many hours can be worked. The government states that individual firms will decide the hours and shift patterns their employees will work on their return, so that they can decide on the best approach for them. It says that the employer must pay the employees in full for hours worked, but furlough pay will be available for normal hours not worked. And it says that employers will need to report the hours worked and the usual hours an employee would have worked in the claim period. And as I said, further guidance on how flexible furloughing will work is expected on the 10th of June. So I'm just going to talk about a few of the practical issues we've thought about, and then I'm going to answer some questions, which I'm sure Matthew will read out to me shortly. So the first one, does your current furloughing agreement allow for part-time furloughing? We need to be thinking about this. Now, again, the current guidance is that to be eligible for the grant, the employers must agree with their employee any new flexible working arrangement and confirm that agreement in writing. So we are going to need a furlough agreement covering the furloughing and the flexible working. Now, if you look at your current furlough agreements you may have in place with your furloughed staff, previously, as employees have been prohibited from working for their employer during furlough, furlough agreements are likely to prohibit employees from carrying out any work for their employer during their furlough period. And indeed, many of the ones that I have seen expressly state you will not work, you shall not work during furlough. Therefore, we're going to need to either amend the agreement by a side letter or enter into fresh furlough agreements with our staff if we want to enter into a kind of flexible furloughing arrangement. And this new agreement is going to need to enable employees to work during furlough and deal with the circumstances in which the employer can require the employee to work. And so you may be setting out hours initially in the agreement. You may be asking for for more flexibility from your workforce, but these are things that we need to be thinking of. So we know that any flexible working arrangement needs to be recorded in writing. And once full details of the scheme are released hopefully on the 12th of June, we'll be able to fully assess what action needs to be taken and what these agreements will need to look like. But just remember that as with your furlough agreement, you're going to need the employee's consent. So you're going to need their consent to any variation in their furlough agreement. And in addition, the new rules may set specific requirements in terms of accessing the scheme where an employee is working part-time. And these will also need to be complied with in implementing any contractual changes. So calculating pay for hours worked. Remember, what we need to do is we will need to be reporting in the scheme to HMRC. We need to report the hours worked and the usual hours an employee would be expected to work in a claim period to basically, enable us to work out how long or the proportion they're on furlough and what the pay is. We're awaiting further guidance on this. I anticipate it's going to be pretty complicated. And I'm not going to second guess how they're going to do this, but wait until the 12th of June. But, even with employees who are on an annual salary, how many hours do they actually normally work in a week? And it's, I'm wondering whether the guidance is going to cover, employees with all sorts of different varying working patterns. So at the moment, we just don't know. But all I can say is that I can anticipate that it may be slightly complicated, but we'll wait and see. And of course, we'll be here to guide you through it once we have that detail. Another thing that we need to be thinking of is ensuring fairness in terms of flexible furloughing. How are you going to choose who to bring back from furlough? How are you going to determine when they're required to work? And I think fairness comes down to, both potential discrimination issues, as well as just in terms of, ensuring that you've got a motivated workforce, because this is a difficult time for everybody and people will have, reasons why they do want to come back and work particular shifts maybe, and how you're going to take all that into consideration, for example, childcare arrangements. So we'll need to be thinking about that. And there are potential discrimination issues when choosing who's coming on and off of furlough. Again, potential childcare issues. I think we discussed this a little bit in our last webinar, but also potential age discrimination is another one. Potential disability discrimination is another one. Age, for example, if you kind of have a criteria, right, we want all our most experienced workforce back, we're going to just go with those that are the most experienced, those that got the longer length of service. We'll just be careful there because there may be a potential age discrimination implication there if it adversely affects the younger workers. And we've also been scratching our heads and just milling, as we like to do in our team, potential issues that might arise. And we thought of one in terms of, a couple in terms of holiday, and potential part-time discrimination. So bear with me as I run through this example, but we have a full-time employee who's been furloughed. So normally works 5 days a week, 5 days a week's been furloughed. And then we're going to ask them to return flexibly. And they're just going to be working 3 days a week, say even from, August through to October. They will receive a full-time holiday allowance because, of course, they accrue holiday while they work, and they also, now it's been confirmed, accrue holiday during furlough. So they get a full-time holiday entitlement. Compare that to your existing part-time worker who may have always worked 3 days a week. Well, they only receive holiday prorated to their 3 days a week. Is that potentially less favourable to the part-time worker? They're working the same amount, same number of days, same number of hours as the full-time at the moment. I mean, our response to such a query would, of course, we look at the contract and this is actually a full-time employee. They're under a full-time contract and therefore they get the full-time entitlement. And obviously their kind of flexible furloughing is a temporary arrangement at the moment. However, you can see the potential for disgruntled employees here. And also there is, again, with the tricky issue of managing holiday at the moment, the potential for abuse because, again, taking this example of a full-time employee who's furloughed but working, say, 3 days a week, they decide they want to take holiday, but actually they know until, say, the end of the following month that they're only going to be required to work 3 days a week. They only book holiday for the 3 days they normally have to work and not for the 2 days they're on furlough. So they only use 3 days of their holiday allowance. So these are things that we might want to be thinking about now, and issues we might want to think about tackling head on once we get further details on the flexible furloughing. For example, having a holiday policy that makes it clear that if employees want to take weeks of annual leave, then they have, if they're on part-time furloughing, part-time working, that they have to take, a full week's leave, and things like that. So those are just some practical issues that we've thought of at the moment. Now I'm going to just deal with a couple more questions that we received prior to the webinar, and then I'll try and deal with some of them others that have come through just now. So we had questions on notice pay and furlough, and basically the question was, if an employee is on furlough and we terminate their employment, say by reason of redundancy, what is their notice pay entitlement? And their question said that they assume the notice during furlough must be 100% unless the contractual notice period is 1 week longer than the statutory notice period for that individual, i.e. same scenario as in sickness, where it must be full pay and not SSP unless the contractual notice is 1 week more than the statutory notice period. Yes, that is our understanding as well, is my answer to that question. We look at what the contractual notice period is, and we look at what the statutory notice period is. So if somebody had 2 years service but was entitled to 4 weeks notice, then we can potentially pay furlough pay at the 80%. If their notice was only 2 weeks, then that's the same as statutory, and therefore they would be entitled to full pay during furlough, so therefore you would need to top it up by the 20%. This is a very unusual provision in the Employment Rights Act, but it's been around for a long time, and that is what we're kind of looking at the moment. And the other thing that I would say is that if you are terminating the employee and you want to kind of access furlough as long as possible, then don't pay in lieu of notice, because you won't be able to claim that grant back from HMRC. The employee needs to the employee needs to remain employed during their notice period. I had another question, which was what pay scale do employers have to pay for notice during furlough? Is it furlough rate or normal salary rate? Well, hopefully I've just answered that question for the person who's asked that one. And the other one that I had was a question in relation to furlough and redundancies. What pay scale do employers have to pay during consultation for redundancies if you're on furlough, as you're not meant to send emails or use company phones? 2 points to probably make on that. First is to answer the question is what pay? Well, the government is clear that actually you can carry out a redundancy consultation process whilst an employee is on furlough. So whilst that consultation process is ongoing, then the employee is just entitled to their normal furlough arrangements, their normal furlough pay. The guidance is obviously clear that you can consult on furlough, and that includes collective consultation as well. But the other point I would make is the comment in the question that is you're not meant to send emails or use company phones. I mean, don't forget, you can still make contact with your employees whilst they're on furlough, and indeed we kind of encourage our clients to do so that employees don't feel cut off. The key here is that you can't require them to perform any work for the company. If they perform any work, then they can't. Then you can't access the furlough scheme for that period. And you can contact them, of course, via, their personal contact details, which hopefully you will have on file. And there is, I understand that there's a bit of a fine line between, okay, are we expecting employees to continuously look at their emails, check in every day for messages? And could that, if they end up starting looking at emails, they might inadvertently start replying to work ones on work matters and below the lines. But the point here is that you can still make contact with them, and what we suggest is actually if you want to make contact with them, you kind of do so on their personal email, and therefore there isn't that requirement for them to kind of continue to be checking their work emails. So Matthew, hit me with any questions.
Right.
And if they all relate to test and trace, and then you can do it.
We've got a couple of questions on furlough. So first of all, there's a long one and a short one. We'll do the short one first.
Okay.
So just to check, the 10 or 20% employer top up is to the employee's wages irrespective of the cap. I don't think it is. I think
no, just to the cap.
Yeah.
Yeah.
So,
sorry, I just had to process that in my mind then. Yeah.
So effectively, you can still, as the employer, apply the cap, but you're going to need to make up the difference between the 2,170, whatever it was, and the 2,500.
Yeah.
Second question, right? This is an exam question. So we have an employee who had a change of contract after the 29th of February 2020 to increase hours, and we use the flexible furlough scheme. How will we calculate the furlough? So, for example, in February, they worked 14 hours. So this is before the increase. But as of March, their contract increased to 28 hours. Okay. So under the flexible scheme, they work 14 hours furlough and are furloughed for 14 hours. Can we make the claim for 14 hours?
Well, my view, and yours might be different to this, Matthews, but I think if we've changed the contract, then yes, you would be able to allow them to work 14 hours for allow them to work 14 hours. They get full pay for those 14 hours, and then furlough for 14 hours. However, I would be interested to know whether HMRC would potentially look at that one and question the motive behind the original contract change. Because remember that HMRC can investigate and said that they will look into furlough schemes. So we need to keep all of our documentation in relation to it for at least 5 years. And I think if they felt that this was potentially suspicious, i.e. a way of employers either kind of accessing more from the scheme that they should, or perhaps employees benefiting more from the scheme that they should, then there may be a potential for an HMRC investigation on that and to kind of ask some questions.
Yeah, I agree with that. The questioner has just clarified that the contract change was planned prior to COVID-19.
Yeah.
And I think that's absolutely right. I think we'll get this will be dealt with in the guidance, I hope. This genuinely seems clearly not to be a sort of an attempt to play the system. And so one would think it was fine.
Yeah.
But I think we can expect to see some anti-avoidance measures in the guidance, which will sort of stop these stop later contractual changes to so as to boost income artificially, perhaps. We're then just going to have to see how HMRC investigate. We know you've got to keep records for 6 years.
Is it 6 years now?
I thought
they started 5. Oh, okay.
They started 5. I
and then
it went up to 6 because
okay.
I think we concluded the 5 was a typo.
Right. Yes, no, we did. You're right. Yeah. Sorry.
So you keep records for 6 years, and whether they're going to have the resources to be able to investigate and audit, who knows? But I think in the case that we've just discussed, yeah, I think you will be able to have the employee working 14 hours and furloughed 14 hours.
Yeah.
Cool.
Shall we move on?
No other questions. So shall we move on to track and trace?
Yeah.
Okay. Right. Hello, everybody. So we're going to be looking at the track and trace scheme. Sorry, test and trace. We all keep on calling it track and trace, but it's actually called test and trace. This is the sort of the linchpin for trying to open up society again, whilst coronavirus is still prevalent in society. And the idea behind it is that rather than have everyone in lockdown, you provide a very significant degree of scrutiny. You provide a high number of tests, and then you isolate those who have tested and those who have come into contact with those who have tested positive for COVID-19, and by doing that, you effectively ensure there is a restriction of the spread of the virus during the outbreak. So that's the theory, and we know that the government has ramped up testing. We know that there are now 25,000 contact tracers. We know that there is a slightly defective app being trialled on the Isle of Wight. All of these are parts of the system. I think Boris Johnson had promised a world-class track and trace scheme to be in place by the 1st of June. I think there's a general acceptance that we don't have a world-class track and trace system in place. Test and trace is at the moment, a work in progress. A lot's going to fall on councils, local authorities.
Sorry, Matthew. Matthew, sorry to interrupt you. You just disappeared then for a few minutes.
Oh, did I?
Oh no, okay, no, for a few seconds. I won't over exaggerate.
I was just saying we don't quite have a world-class track and trace scheme yet, but hopefully we will do over the next few weeks. So that's what we're now living with, and I think it has some very significant implications for employers. The government seems to think so as well, because it has issued separate guidance to employers on how to manage test and trace. And there's a link to it on the screen. It cross-refers to the documentation that many of you will already have seen, which is about how we return to work and how we open up workplaces, etc., whilst they're still we've still got to distance. So it's worth looking at those two together. Now, I think significantly at this stage, what we don't have is any legislation. There's no legislation requiring people to report when they have symptoms of coronavirus. There are no requirements, no legal requirements to actually isolate or to fess up on contacts. So at the moment, it's a highly voluntary scheme, and I think the government hopes it will stay that way, but they may have to bring in legislation. Now, the fact that it's voluntary, I think to a certain extent gives us all a degree of a bit of a headache, because it increases uncertainty and gives a degree of discretion. So we've just got to bear that in mind when we're looking at how we deal with it. How will the scheme actually work? Well, here's a slide you may already have seen, because it's the government's straightforward guidance on test and trace, and you'll see that it's split into two. On the left are what happens if you've got coronavirus symptoms. You start isolating, you book a test, and then you're either negative for COVID-19, in which case your household no longer needs to isolate, and you no longer need to isolate, or you're positive for COVID-19, in which case that's when the test and trace system really should start to come into its own. You provide details of your contacts. They are then risk assessed, and if they are likely to be have been infected by COVID-19, then they will also be required to isolate. And those are the ones who are dealt with on the right of this. So you might have been alerted by test and trace that someone who you have had close contact with is positive, or you may have been informed by somebody who is positive that they are positive, and therefore you've got to take that seriously. So if you're alerted, then there's a 14-day isolation period. If you develop symptoms, then you can then book a test, and that's where you move back to the blue side of this. If you're positive, or if you're not positive, then you need to you can stop the isolation. So that's really the way it's going to go if it all works. If it all works in the way in which the government wants. There will be teething troubles, obviously. Now let's just think about what this may look like from an employment perspective for us. We are going to have employees who are calling us at short notice saying, right, I've got symptoms of COVID-19, therefore I've got to isolate. We are going to have employees contacting us saying that they share a house with someone who has got symptoms of COVID-19, and therefore they are also going to have to isolate. And we are going to have individuals who are contacting us to say, I've just been told by NHS test and trace that I've got to isolate because I've been in contact with someone who's tested positive for COVID-19. So we're going to have to find a way of dealing with all of that. I think potentially quite large numbers of very short-term absence, which short-term in terms of our notification of it, which then can continue for 14 days. And that might be a pattern repeated again and again and again. We also have the other complication, which is actually one of the places where many of us will most closely come into contact outside of our immediate household, is the workplace environment. So again, we're going to be potentially in a situation where many of those who are being contacted by NHS Test and Trace are going to be colleagues of the person who has tested positive. So there's some real implications, I think, there for employers. And I think what we can do now is just have a look at a bit what the government's saying about them, and then how we might start to deal with them. So what does the government say about test and trace and the role of the employer being? And remember, no legislation about all of this. It's all at this stage sort of voluntary, sort of everyone doing their bit. Well, the first role for employers is obvious: make workplaces as safe as possible by following government guidance, and that's the second the second link I put up on the first slide. Secondly, encourage workers to heed any notification to self-isolate and support them within isolation. Now, this is an interesting one, and again, back to the fact that there's a degree of voluntarism about all of this at this stage. It's not going to, be a case of employers saying ignore track and trace, ignore test and trace, rather ignore the fact that you've had that call, come into work anyway. The government is expecting employers to do their bit and to ensure that workers are not encouraged to or are encouraged to self-isolate. Now, that's easier said than done. We can all issue a sort of notification saying, if you are notified that you must self-isolate, then please do self-isolate. But clearly it has knock-on effects, particularly if the employee feels that their wages are going to be affected, or somehow that they are otherwise going to be penalised in the workplace as a result of what they are doing. So we're meant to make encouraging sounds, but one way or another, we're going to have to look at how we back this up. So just a few sort of things to consider. As I said, the scheme currently is voluntary. Matt Hancock did say that if there wasn't enough take-up, then they would have to introduce legislation. I was listening to something talking about the experiences of the what's been happening in the Far East around track and trace, which has been very, very successful. But it has been it has been a very, very intense system of follow-up with individuals, getting the police to check on individuals, etc. We are a long way at the moment from that kind of scheme. At the moment, it's voluntary. I think there are going to be health and safety issues, however. So, I think if we have an employee who notifies us that they have been told to self-isolate, but we tacitly encourage them back into the workplace, or at least we don't discourage them from coming back into the workplace, then I think we are going to be potentially breaching our obligations around safe systems of work, etc. So that may be a potential sanction on employers. Just one other point, the Test and Trace Service will issue certification when they have notified someone that they should isolate. And that certification is going to have to be accepted by employers as evidence of the fact that the employee must remain away from work. So there is some formality in this process at some stage. What does the government say? Well, what I thought I'd do is just go through some of the key bits of the guidance, and we can pick the bones out of that, and then look at what it means from a practical perspective. So what does it say about pay? Employers should continue to communicate with workers in self-isolation and provide support. This includes allowing people to work from home if they remain well and if it is practicable to do so. Okay, straightforward so far. This may include finding alternative work that can be completed at home during the period of self-isolation. So clearly the government is intending that we all continue to be productive from home. Self-isolation is not the same as sickness absence from that perspective. What happens if people can't work from home? Well, employers must ensure any self-isolating employee is receiving sick pay and give them the option to use their paid leave days if they prefer. Further guidance is available on what employees should do if they cannot work. So this is a sort of quite an interesting thing to try to pick the bones out of. So if you can't work from home, then you receive sick pay. You will be able to receive statutory sick pay, and the notification I talked about earlier will be evidence which allows statutory sick pay to be claimed. This quote, however, refers to sick pay, not statutory sick pay, not occupational sick pay, just sick pay. And this is something we've seen from the government before when it's been issuing guidance. At the very, very start of all this, when self-isolation started, they sort of tried to blur the lines between statutory sick pay and occupational sick pay. My take on this is that the government would like every employer to pay full occupational sick pay if the employer pays full occupational sick pay during any period of self-isolating, even if the employee cannot work. But there's certainly nothing that can require that to happen. We'll come on to what we do about that in a minute. And as you see, there's further guidance there for employers. But certainly there will be pressure on employers, I think, to pay full pay, or at least sick pay. What else? Employees in self-isolation are entitled to SSP for every day they're in isolation, as long as they meet the eligibility conditions. And effectively, I've just sort of preempted that by saying they will get that certificate, which is notification of isolation. They will need to provide that to the employer, and you will need that as the employer to claim back the SSP. And the eligibility conditions are the usual ones around minimum rates of pay, etc. What else they're saying? An employee can ask to take their paid holiday for the time they're off work, entitling them to full pay for the duration of their leave, as opposed to statutory sick pay if they choose. So an employee can ask to take paid holiday. Is that the same as requiring employers to grant paid leave? I don't think it necessarily is, but again, it's the way in which the government is trying to do these things, is to put pressure on employers to find ways of making sure employees are fully compensated. Now, what really comes out of all this, I think, is the fact that there is an awful lot of uncertainty. There is an awful lot of exhortation to employers to do the right thing, without necessarily giving employers an awful lot of guidance as to what the right thing is. So how are we going to deal with this in practice? First of all, are we looking at SSP or occupational sick pay? I think the fact that the government refers to SSP being paid for someone who is self-isolating gives us a few issues. I think, and the reason I say that is because I think ordinarily what happens is occupational sick pay will follow statutory sick pay. If someone's entitled to SSP, then they're likely to be entitled to occupational sick pay, subject to discretions, etc. And I think, therefore, there is going to be a presumption that if an employee is self-isolating, that occupational sick pay, if they are entitled to it, will apply and will be expected to be paid. So I think if you want to not pay occupational sick pay, and at the moment you do not have a discretion over that, at the very least, I think what you do is introduce some kind of discretion so that you can make the decision as to whether you are going to top up SSP to full pay or half pay or whatever your sick pay scheme is in the situation of someone self-isolating. But I don't think we should assume that the two would just be treated separately. I think we need to look at having a specific statement on that. One of the things that I'm just going to put out there is the idea of an occupational furlough scheme. I've heard of a couple of clients talk about this. Larger organizations talk about it in particular. But this idea that actually what they will want to do is to deal with COVID-related absence issues separately from sickness issues, and therefore putting in place a separate scheme, perhaps a less generous scheme or one which is more under their control, for dealing with employees who cannot work because of the consequences of coronavirus. So it might be because they are self-isolating. It might be because their workplace is having to close because there have been so many cases of COVID within a particular workplace. It might be to sort of reduce childcare burden or that kind of thing, or at least take into account childcare burden, that kind of thing. But it's certainly, I think, worth looking at. I know it's a difficult ask at the times when nobody is going to have spare money to spend on these things, but certainly looking at how we might start to manage COVID-19 related absences separately to sick pay. Here's another one for you. Should we be making it a disciplinary offence not to self-isolate? I think yes is going to be the answer to that. I think it's going to be important to be shown that you are doing the right thing as an employer to pay your part in the fight against COVID-19. I think how far we take that will need to be seen. So, for example, if you have symptoms but you don't report those symptoms to test and trace, could that be a disciplinary offence? If you test positive but don't report to the workplace, could that be an issue as well? So there's certainly something, I think, around this that we're going to have to start looking at how we deal with that. Interesting that, just going back to the guidance sort of plans for the situation where an employee says, right, well, okay, I've got some symptoms of coronavirus, I'll phone up the NHS and book my test, but it's going to be 48 hours, perhaps longer, before the results of that test come through. And there's some guidance about how employees should deal with that. And effectively, what should happen is, if the employee should, once they've phoned and booked their test, they should then talk to their employer and say, I've got these symptoms, so I booked a test, I'm going to self-isolate in accordance with government guidance. The employer, I think, together with the employee, then needs to decide whether or not they communicate that to other employees who may, at that stage, have been in contact with the employee who's got symptoms. Now, there's no obligation on either the employee or the employer to do that, and at that stage, employees who have been near that employee should not self-isolate. But we might want to look at some internal procedures just to ensure that we are ahead of the curve. If an employee reports with COVID-19 symptoms before they've had the positive test, what are we going to be saying to other employees, etc.? So again, just something else to consider from a workplace planning perspective. I think the other thing we might want to do to plan for this is just identify those duties that can most easily be done from home or in isolation, and perhaps then reserve them for those self-isolating. Won't be possible for all types of work, won't be possible for all types of economic activity, but certainly just thinking ahead and thinking, right, where we're going to have employees self-isolating, how do we plan for this? And again, it might require some changes to workplace flexibility, etc., and what we're doing and where we're doing it. Another one I thought worth just considering is changes to holiday rules. Now, again, as you've just seen from the guidance, the exhortation is to allow employees to take holiday if they're self-isolating, should they request it. And again, the reason is obvious. There may be employees who very quickly start to use up all of their holiday entitlement on isolating. Who knows? But what happens if you're towards the end of the holiday year, you've already taken an awful lot of holiday and you haven't got it left? I can see a situation where we might actually allow employees to dip into next year's entitlement as well as using the current year's entitlement. So again, we might find some more changes towards holiday as well. Those of you who have watched some of our other webinars will know that we see holiday and how we manage holiday over the next few years as a really big issue for employers. And this may be another thing just to take into account if you're looking at putting in place a new holiday procedure. Obviously, that's got to fit in with the working time regs as well. So there's some practical issues there. I think there's some more. How are we going to deal with the constantly self-isolating employee? The employee who always seems to be off in self-isolation because they seem to have contact with so many people who are contacting coronavirus. To what extent can we say, well, come on now, you're really going to have to start changing your ways if you're spending 14 days every 2 months self-isolating because you've been in contact with people. So to what extent are we going to bring this into our absent management procedures. I think we should do, and I think we're going to have to, but we're going to have to do it carefully, because of course there is this key balance between ensuring that employees do self-isolate, that they do report, and at the same time don't feel they're going to be penalised for that. But I can see this being an issue, and again, I think we might want to bring it in if it looks like it might be an issue. I think we also have to look at the fact that I think there are going to be many cases where test and trace effectively closes a department or a workspace or a particular retail unit or similar, because that is where the main contact is going to be if an employee is tested positive for COVID-19. So I think we have to look at this. We probably have to look at the lessons from schools and businesses that have been staying open, which is how we manage teams to ensure that the effect of lots of people self-isolating at once is mitigated. So just consider again that in your workforce planning. And again, it's one of these things we may want to change over time. I've referred there to the super spreader, which really goes back to the fact that there will be people who are more in contact and more likely to be exposed to others who have got COVID-19, and how we deal with them in the workplace and who they might be working with, etc., needs to be considered very carefully. The final point I would just make is poor old self-employed contractors and other consultants. We know they've been particularly hit particularly hard by this, given the fact that not all of them have been able to make use of the job retention scheme or the similar funding in quite the same way as employers have. I think when we're looking, however, at that fact, and when we're looking at the fact that contractors, consultants, etc., tend to be paid only for the work they do, if we routinely have self-employed people coming into our workplace, then I think we've got to take into account the fact that some of them may be slightly hitting and hoping and will perhaps downplay symptoms, or will not necessarily be following the test and trace notifications in quite the same way, and there could be quite an easy spread of COVID-19 within a workplace if someone comes in with it. So I think we have to start looking at who else comes into our workplace and why. And if we routinely used contractors, consultants on a pay when play, pay when works type basis, then I think we have to be quite clear that we do not want them in if they have symptoms or if otherwise they should be self-isolating. How do we do that? It's difficult. The obvious way of doing it, and I say this as a lawyer, so we always find a legal solution to things, would be to look at modifying consultancy agreements, etc., to add a clause in that says that when they appear for work, they are warranting that they do not have symptoms of coronavirus or symptoms of COVID-19 rather, and also that they have not been issued with a notification of the need to self-isolate at that point. It gives us some degree of comfort. I think if these things are in a legal agreement, at least it pulls people up and says, well, should I be doing this, or am I going to be in breach of contract? But we do need to start to consider the others who are going to be going into the workplace in the same way. So early days for test and trace. They're really some of the issues I just feel we should be starting to get to grips with. There's no answers to any of them at the moment, but I can see how boards are going to start to look at this and say, right, give us a strategy paper on what the issues are, and hopefully that will give you a head start as to where some of these issues are going to be. I think we've got a few questions on
we do. We've got, I think, one from me. Sorry, not from me, for me, and a couple for you. So one question that came through is, from the guidance issued so far, it seems that while staff can be put back on part-time / flexible furlough after the 1st of July, they cannot be put on 100% furlough / no work Do you have any further information on this? Well, this, I must admit, got me frantically rereading the coronavirus job retention scheme updates, because that certainly wasn't my understanding, or indeed I might include Matthew in that group, of our understanding that actually furlough staff that have been previously furloughed can't be put back on kind of permanent, not permanent, but full-time furlough. And as I said, I've kind of re-looked at the guidance, and I can see why that question has arisen, because there are statements from the government that say things like, from the 1st of July, businesses will be given the flexibility to bring employees back part-time. So does that mean they don't have the flexibility to bring them back and keep them on furlough? But I think, when we look at other parts of the scheme update, it kind of says to enable the introduction of part-time furloughing and support those already furloughed back to work. Claims from July onwards are restricted to employees currently using the scheme and previously furloughed employees. And I think that's the point. I think because they want to introduce part-time furloughing, and I think the government's probably genuinely concerned that actually as soon as they introduce it, suddenly another 25% of the workforce will suddenly be put on part-time furloughing, part-time working, and they want to be able to restrict that, and they don't want employers to be able to go, actually, this is quite a handy way of us being able to reduce the hours and the pay of our employees who've been working up until now. So I am reasonably confident that actually from the 1st of July you can put employees who've been working back on full-time furlough, as it were. And it's certainly, I don't think it's been and I don't think the intention of the guidance that's been issued is to say that no, if people come back, they can only, or if people are put on furlough, it can only be part-time furlough. However, I will be eagerly awaiting now the 12th of June announcement to see whether my assumption is right. Matthew, did you have a feeling that people only be allowed to be put back on furlough part-time?
No, I think I absolutely agree with you. I think the noise is coming from...
Matthew, have you muted yourself?
No, can you not hear me?
Oh, no.
Hello, can you hear me?
No.
Maybe I'll press the button or something. Hello, can you hear me now?
No.
Hello, testing, 1, 2, 3.
Amy says that she can hear you. So maybe others.
Yeah. Well, I'll carry on talking.
Can. It's just me that can't. Don't worry.
Okay. I'll do sign language for you. I think I agree with your answer. The government wants this to be as flexible as possible for a few months. And I think that will be, there will be this maximum flexibility, but we'll update when we've seen the guidance. I'll just deal with a few points on the test and trace and what's come out of that. So is a self-isolation note or doctor's certificate needed to claim SSP for sickness? Yeah, effectively, if someone is isolating, they will be entitled to, at the very least, I've said SSP. And the test and trace service will issue a notification, which the employee will need to send to the employer. And that will be the employer's proof to enable them to claim back the SSP. And I think as we see with other occupational sick pay schemes, if you're going to pay occupational sick pay here, then that will be the kind of proof which you can require for any sick pay you receive. Another question, what happens when an employee rings in to say they're not well and have symptoms, but they refuse to have a test? That's a good question. I think if we just look at what the government guidance is saying about this, effectively the response should be, no, you need to get yourself tested, but we can't make employees get themselves tested. We cannot also require them to call test and trace. I think what we at that stage do not have to isolate or inform other employees, but at the very least we should be conducting some kind of risk assessment just to see whether or not the employee may be likely to have infected others if they are COVID-19 positive, and that's certainly what the government guidance suggests. It may be, however, we then need to think about their return to work. So if they've got COVID-19 symptoms, whether they've been tested or not, they need to isolate for at least 7 days, preferably 14, unless they've actually had a positive diagnosis of COVID-19. So at that stage, you don't need to apply test and trace because that's not your responsibility. But as I said, I think we do need to look at how we start to build in some sort of obligation on employees to inform us and to do the right thing under the test and trace scheme. Couple more questions. Could you just clarify the pay due in notice for a contractual 4-week notice period, furlough pay or full pay? Lawyers answer, it depends. And it depends because it depends upon what the employee's statutory notice period is as opposed to contractual notice period. If the contractual notice period is the same as or no more than 1 week more than statutory notice, then they will be entitled to full pay. If, however, it is significantly more, then they will be entitled to furlough pay only. So if you've got someone with 4 weeks pay, 4 weeks notice, what you've got to ask yourself is what's their length of service. If their length of service is up to 4 years, then you're going to have to pay them full pay. There's a slight query in my mind if it's up to 5 years, whether it's full pay or furlough pay, but we'll put that aside for one moment. If it's more than 5 years, then they're going to be on. Sorry, I'm going to start that again because I've lost my thread. I'll start it again. If they've got 4 years service, then it's going to be full pay. If it's 3 years service, then it's going to be full pay because it's statutory plus 1 week, I think. If it's less than 3 years service, then it's going to be furlough pay. Okay, I think that's right. Vanessa will confirm if I'm wrong because she's.
No, that's right. No, we've got that.
Fine. And then we've got one last question. Can you please recap what areas should be covered in an amended holiday policy to take into account track and trace and part-time furloughing, etc.? Gosh, that's a whole seminar in itself, and maybe we should do one on holiday coming out of this. Yeah. I think what our thinking is on this is first of all, just for the whole holiday story, for those of you who've got time. First of all, the holiday is going to be disruptive for some time, for various reasons, and there will be employers who are storing up large amounts of holiday, which it's going to be very difficult for them to allow everyone to take during this year. So what the government's allowed is carry forward of holiday for the next 2 years, even though that's not technically allowed under the working time regs. So the first thing the holiday pay needs to do is look at how you are going to be allowing carry forward of holiday for the next 2 years, number one. Secondly, I think you're going to have to be far more directional with regards to holiday. I think many organisations are quite lax about allowing employees to take it and when they take it. I think it's going to be important that we make employees aware of the fact that holiday is going to be rationed, and they can expect to be either required to take it at certain times or not allowed to take it when they want to take it, because workforce planning is going to change. And I think that's the big thing around test and trace. I think the next thing when we're looking at test and trace and holiday, are we going to specifically refer to the fact that if an employee is isolating, then they can apply to have their holiday as opposed to just being on SSP? Secondly, are we going to allow employees to carry back holiday from previous holiday years? Let's say we've got a holiday year, which is a statutory year, which is a calendar year. They've used up all of their holiday entitlement, and then on the 1st of December, they are told that they've got to isolate for 14 days, let's say 10 days of those are work days. Would you be prepared to say to an employee, yes, you can bring holiday from your next holiday year back to this holiday year to allow them to do that? I think if so, then we're going to have to look at how we put that into a holiday policy. So those are the kind of things we're going to be taking into account. I think furlough pay or take into account part-time furloughing in holiday is again a difficult one. As Vanessa says, I think there are some part-time discrimination issues there. Best off dealing with it in a policy. to make it clear that if you have an employee who is furloughing, even if they are working part-time during furlough, if they are a full-time employee, then you are still going to treat them as a full-time employee for the purposes of holiday and holiday entitlement. I think even though that may look as if it's unfair to a part-time employee who is perhaps by that stage working the same amount of days in a week as the full-time furloughing employee, I think the important thing will be to deal with it in the policy. So there's 5 or 6 things I think coming out of furloughing, coming out of lockdown, coming out of test and trace, coming out generally of COVID-19 that we need to be looking at in terms of a reassessment of our holiday policy. And we really are encouraging employers to look at this and to look at holiday policy as a key part of their workforce planning in response to COVID-19. I can't see any other questions, Vanessa.
Yeah, so, I can. I think we might have skipped one, but then that's when I struggled to hear, but everybody else could. So it's probably just my end. Did we answer the question, which was SSP is only granted for a certain number of days? What if they're self-isolating, unwell for longer than this period?
No, we didn't.
Oh, good. Do you want to answer it?
I think what you would do is, I think that would be hard luck to the employee to a certain extent. If they've used up their SSP entitlement, then they've used up their SSP entitlement. Of course, the rules did change, so it applied from day one without a waiting period. I seem to remember right at the beginning of this. But effectively, if you have an employee who's used up their SSP, then they're not entitled to any further SSP under the scheme. If you decide to pay them SSP, you won't be able to claim it back.
Yeah. And then we had a question, can we confirm redundancies during a period of furlough? So the quick short answer to that is yes. And indeed, I think we're helping many organisations at the moment conduct redundancy consultation processes whilst employees are on furlough. And indeed, you can go ahead and confirm redundancies during a period of furlough. That's absolutely fine. And then for one of your answers about the holiday, we've just got to thank you for that, and it'd be good to have a specific webinar on holiday and management of such. So we'll add that onto our list, Matthew, shall we?
Yeah.
I think what we'll probably do is we'll probably look to do one shortly after the final details come out on the 12th of June.
Yeah.
And then we'll also look to do one shortly on holiday as well, because there's a lot. And I think it would be good actually once we see the details of the scheme, because that probably also impacts a little bit in terms of holiday and furloughing, won't it?
I think it will. And there's going to be a lot of devil in the detail, I think.
Yeah. So I think that is all of the questions. So thank you once again for all of your questions and for engaging with us this morning and for listening to us. And oh no, there's one more question. Regarding the SSP entitlement, hasn't the government said that the usual 28-week limit has been lifted during the pandemic?
Oh, good point. I wasn't aware of that, but I don't keep up to date day to day on the SSP regs. So we'll look into that and we'll get back to you.
Yeah. I am just making a note of who asked that. So that's SSP entitlement, 28-week limit lifted. Fine. Yeah, good question. So yes, once again, thank you all for listening. Thank you for your questions. Any other questions you think of afterwards, then do email. I'm sure you've got our details, and we will see you, no doubt, in a couple of weeks for our next webinar, hopefully.
Okay. Bye, everyone.
Thank you very much. Thank you. Goodbye.